Mic check 1 2. Mic check 1 2. Good morning, everyone. This is the 9:15 audio check for our stream. As a kind reminder, when you approach the podium to speak, please make sure that the light is on. If it is not on, simply turn it on by hitting the push button. And after you are done speaking, please push the button to mute the mic, as I'm about to do right now. Mic check 1, 2. Good morning. This is the final captions check for our live stream. The time is around 9:25. As a kind reminder to those that are in the room, if you are speaking today, please make sure that your light is on before you begin speaking, and also leave about a 6-inch gap to the microphone so you can be heard. And after you are done speaking, please push the button to mute your microphone, as so those that are online won't be able to hear your private conversations.
The government code prevents us from starting early. I appreciate everybody being here and being so quiet and ready to go. I'm ready to go too, but it would be a violation of our open meetings laws. So 3 minutes.
Suggestion from the feeling gallery that you could lead a mindful meditation for 3 minutes.
I see at least one clock that says 9:30, so we're going to get going here. Good morning, everyone. It is my pleasure to call this meeting of the Texas Commission on Environmental Quality to order. Today is Wednesday, August 28, 2024. As I said, the time is 9:30 a.m. With us today are Commissioner Bobby Ginecca, our General Counsel Mary Smith, and Commissioner Caterina Gonzalez is joining us virtually. Good morning, Commissioner Gonzalez.
Morning.
And her audio is working. We're off to a good start. Registration has now closed, but if you'd like to address the commission, I'd ask you to please visit our registration table or email agenda@tceq.texas.gov with your name, affiliation, and the item that you'd like to speak to, and we will try to accommodate that request. For those who are addressing the commission, our general counsel or I will let you know when it's your turn to speak, and we'll inform you of your time limit. Thank you again for being present today, and Ms. Smith, I'm ready for you to call the first item.
Item number 1 is the consideration of the ALJ's proposal for decision and proposed order concerning the application by Uranium Energy Corporation for a renewal and amendment of permit numbers WDW 423 and WDW 424. The order of presentation will begin with the applicant, followed by the protestants, the ED, and OPIC. The applicant, protestants, collectively the ED and OPIC will each have 5 minutes for oral argument, and the applicant may save time for rebuttal as it bears the burden of proof on the application. And so with that, we'll begin with the applicant, and I believe we have Mr. David Tuckfield here.
Good morning.
Good morning, Chairman and Commissioners. Thank you for letting me have this oral argument. I was going to reserve 2 minutes for my rebuttal. There are 2 very important points with this PFD. One, this is a renewal and an amendment, so it addresses the same faults, the same geology that were found adequate by this commission in May of 2010. And secondly, the regulatory scheme in this case for Class 1 injection wells is unique in many respects. The most notable of which is the fact that after the permit is issued, when the wells are drilled, additional site-specific information is obtained, a completion report is prepared, and additional tweaks are made, and additional requirements can be imposed on the applicant. And that actually has become just an overarching theme throughout this proceeding, because what we see happened was that the protestants and the ALJs moved the post-permitting procedures to the pre-permitting procedures, and that's how we feel everything got off track here. But let's talk about the specifics of the PFD and the issues at hand. First, the geology. The big dispute was whether there was enough local geology provided in the application. And if you look at the rule and the rule, it just says that you have to consider an analysis of local geology and hydrogeology. To do that, we look at the instructions from TCEQ, and we've set out in our exceptions all the instruction requirements and where we've satisfied all the instruction requirements. And that wasn't really an issue at the hearing. The issue then became, well, there's other things that you could have done to get more local geology, to get more site-specific information. And frankly, it just isn't required. Sure, we could have done more. And yes, the instructions could have required more, but it's not required. And so it's our position that this PFD went overboard in requiring site-specific, confusing site-specific information with local information. Basically, the ALJs have rewritten the rules as far as what is required for this application. For example, at page 67 of the PFD, the ALJs say that it would be possible to drill a well or conduct a pump test to obtain more specific information. Well, it's just not required. Sure, it's possible. Bottom line is the geology has sufficient local data for you to approve this. The assessment of faults, 331.121A2P says that applicants shall demonstrate that the faults are not sufficiently transmissive or vertically extensive unless previously demonstrated to the commission that that's the case. And in this case, it was previously demonstrated. The permit was issued in 2010. These are the same 11 faults that were in the original application. The geology hasn't changed. But even if a showing was required in this case,
that's 3 minutes.
And even if it was required, then it's clear in our exceptions that was the case. Bottom line, and I'll save the rest of my time for the rebuttal, but the bottom line is they really moved the post-permitting procedures to the pre-permitting procedures. Thank you.
Thank you, Mr. Tuckfield.
So we have Mr. Friedman and Mr. Bennett, and I understand they're going to split their time 4 minutes and 1 minute respectively.
Good morning.
Good morning, Chairman, Commissioners. My name is Adam Friedman. I'm here on behalf of the Goliad County Groundwater Conservation District. I have a few of the board members and the president with us here today. And what they found early on in reviewing this application was that there were two serious problems with the proposed disposal wells. And that is that there were 11 faults identified within the area of review, 5 of which extend vertically from the injection interval up through every formation and into the Evangeline Aquifer, which is their sole source of groundwater in Goliad County. One of those faults extends all the way from the injection formation into the Evangeline Aquifer, which is the closest of the faults, about 1,500 feet away from the proposed disposal wells. And what the district knew is that this bare minimum application, which were words adopted by the ALJs, minimum effort by UEC, to do any demonstration that those faults were not transmissive of fluids. And the district knew that their groundwater wasn't protected, and that's the entire premise of these Class 1 well applications. You must demonstrate that USDWs, let alone freshwater, but USDWs of 10,000 TDS or less must be protected before a permit is issued, not after, before the permit can be issued. And the ALJs understood that the 3 issues referred by the agency were rooted on that requirement. And they found on all 3 issues that UEC failed to meet its burden. First, they failed to demonstrate that the faults near the proposed wells were not transmissive and would not allow migration of fluids into the USDW or aquifer. Conclusion of law 19. Now, that was found because all UEC did was rely on a regional report of the Gulf Coast, which was from Brownsville through Louisiana, that faults in that area tend to seal themselves. But what we found out is that wasn't good enough, that the same report that was referenced for that finding by UEC also says you got to do a site-specific, a closer analysis of the faults at the site. And what we found is that every formation where those faults were included sand. And that's important because when the fault occurs, that fault becomes a mixture of the material that's in those formation and that it's potentially transmissive. And of course, faults and nearby well bores, which was the other issue as to why this aquifer and the USDWs weren't protected, were nearby well bores. And it's hydrogeology 101 that those can be pathways for fluids that circumvent any confining layer. And that's why that's so important. Even though we found in the hearing that the alleged confining layer, the anahuac, which is supposedly the clay, more clay confining layer, didn't even exist at the site. That's what UEC's cross-section showed. But even if it did, at the fault closest to the well was clay on one side and sand on the other. You know, zero, very minimal effort to demonstrate that these faults were not transmissive. Secondly, the well bores, there's 2 that were found within the area of review, one of which was 1,500 feet away, that the Railroad Commission records documented could not have been plugged based on the timing of some of the cement jobs. And the ALJs found that those 2 well bores are potential pathways that were not proven to prevent injected uranium wastewater mining from migrating up into the USDWs. That was issue C. In issue B, the ALJs found that because there were these potential pathways, the failure and the lacking of any groundwater monitoring to detect these fluids was an inadequate monitoring system in the draft permit, which is required by TCEQ 331.64. So
that's 4 minutes.
Let me just say that it's not even clear that UEC disputes that they failed to meet this burden. What they would have is that they'll figure it out later. They'll come back with the ED and the staff and get behind the agency, and we, the public, will have already been eliminated its opportunity. And it's very clear. I just want to mention these sites before I hand it off to Mr. Bennett, but you cannot issue a Class 1 permit until after UEC proves that USDWs are protected. Chapter 27.051A of the Water Code, 331.5 of the Administrative Code. 331.121C, all emphasize before the permit. This completion report does not replace the permit application. It complements it for before injection begins. And with that, just ask that you adopt the ALJ's PFD, remand this back to the staff under your authority to do so, develop a real application, put it up for public comment, or alternatively, as the ALJ's requested, to deny the permits. Thank you.
Thank you, Mr. Friedman. Morning, Mr. Bennett.
Good morning. My name's John Bennett. I'm representing a group that in the record of this case is called the Landowner Protestants. It's 11 landowners who live around the project.
That's time.
Go ahead and
Thank you,
share,
sir.
share a summary of your thoughts with us.
Sure
Yeah,
thing.
Thank you.
My clients, one of them has been in the area on Coletto Creek since 1843. Others came more recently. What they all share is that the only source of groundwater in this, the only source of drinking water in this area is the groundwater. And so they were deeply concerned by this application. They pooled their resources to try to test UEC's proof at the hearing. And what they learned was that their concerns were more than justified, because the theme of this hearing that has already been touched on by everybody who's spoken before me reminded me of Nancy Pelosi's infamous remark, "You got to pass the bill to find out what's in it." Time and time again, what the evidence showed was that all UEC had done was conduct a desktop review based on whatever sources were easily accessible from the desktop. And where that information was highly generalized or sketchy, the response was, "Don't worry about it. We'll figure it out when we drill the well. You got to give us the permit to find out what's down there." And our submission is that can't be the way your rules work, because if it is, the perverse effect is it becomes easier to get a permit the less you know about the subsurface. And so that is our ask. Don't read your rules that way, because they don't make any sense that way. It puts the cart before the horse. The rules clearly require a showing of adequacy before you get the permit, not after. Thank you.
Thank you, Mr. Bennett.
The ED. Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I'm Don Redmond, an attorney with the Environmental Law Division. With me today is Dan Hanna, PG, a geologist with the Underground Injection Control Permits section. The Executive Director respectfully recommends the Commission make findings and conclusions that UEC has met its burden of proof on all issues, and that final draft permits WDW 423 and WDW 424 be granted. With respect to the first referred issue, the Executive Director contends the record supports findings and conclusions that the application adequately characterized the geology and adequately identified and assessed faults in the vicinity of the proposed injection wells. On the second referred issue, the Executive Director contends that the record supports findings and conclusions that the draft permits provide for adequate monitoring of injected fluids in the vicinity of the proposed injection wells under applicable laws. On the third and final referred issue, the Executive Director contends that the record supports findings and conclusions that the location of the injection wells and the pre-injection facilities are adequate. The Executive Director acknowledges that the subject injection wells were not drilled and constructed during the original term of the permit. If the permittee decides to install the injection wells, the Executive Director would have the opportunity to review well construction and review the submitted well completion report before the wells can be put into service. The Executive Director's review would include consideration of the injection and confining zone testing program, a calculated area of review and cone of influence based on data obtained during well logging and well testing, and the status of any corrective action required for defective wells in the area of review. Thank you for your consideration. We're available for questions.
Thank you, Mr. Redmond. I have none. Any questions, Commissioner Chineka? Commissioner Gonzalez? Any questions for Executive Director?
No
staff?
questions. No,
Okay.
thank you.
Thank you. Thank you, Mr. Redmond.
OPIC.
Good morning.
Good morning, Chairman, Commissioners, Executive Directors, Attorneys and Staff, General Counsel. For the record, I'm Jennifer Jameson on behalf of OPIC. Upon consideration of all evidence, OPIC respectfully recommends denial of this application, or in the alternative, OPIC agrees with the ALJ's finding that UEC has failed to meet its burden of proof in this matter, and that it should be remanded to the ED for further examination. Specifically, OPIC re-urges the concerns raised in our closing argument and maintains that the evidence presented does not prove that the application adequately characterized the geology and assessed faults, or that USC has made a sufficient effort to investigate the project site for transmissivity of the faults. Further, OPIC maintains that ambient monitoring should likely be required for this project pursuant to Rule 331.64H1. With respect to characterization of geology and assessed faults, OPIC agrees with protestants in the ALJs that UEC's predominant reliance on regional data is insufficient and does not comply with the clear mandate of applicable laws and TCEQ rules. Relevant rules clearly state that the Commission cannot issue a Class 1 injection well permit until after the applicant proves that all USDWs are protected from migration of fluids from the proposed injection interval. Here, the applicant and ED offered extensive testimony about the post-permit issuance process, the idea that once wells are drilled, site-specific data will be collected to confirm the adequacy of characterization of local geology and a completion report submitted to the ED. OPIC, protestants, and the ALJs all counter that the notions of issue the permit first and then confirm local geology is inconsistent with the clear mandate of TCEQ rules, which specify that the minimum criteria for siting before issuing a Class 1 injection well permit requires that an applicant to describe and analyze local stratigraphic and structural geology and include at a minimum detailed information regarding stratigraphy, structure, and rock properties. That is, the applicant must provide pertinent local regional data prior to permit issuance and not the other way around. On another note, as discussed in our closing argument, OPIC is concerned by UEC and the ED's contention that required local geologic data can be gathered after issuance of the permit via a completion report because there is no requirement for public notice indicating submission of the completion report and no opportunity for public comment, and the public may not request a hearing to contest the findings of the report despite relevant statutes specifying that pertinent data be submitted to TCEQ prior to permit approval. The ED rightly points out that notice and opportunity for a hearing would arise from any major amendment to the permit application, but OPIC stands by its concern due to the fact that the determination of what constitutes a major amendment is entirely within the ED's purview. Lastly, OPIC urges ambient monitoring should be required under Rule 331.64H1. Specifically, OPIC agrees with ALJ's finding that there is extensive evidence to show the potential value of monitoring to Hausman number 2 well to detect fluid movement because the level of total dissolved solids in the ejection interval is almost 4 times that in a USDW and can degrade the quality of a USDW. This is particularly worthy of careful consideration given that groundwater is the sole source of drinking water to nearby residents in Goliad County. Thank you. And I'm available for questions.
Thank you, Ms. Jamieson. I have none. Any questions? Seeing none. Mr. Tuckfield, you have a rebuttal?
Thank you. Just a couple issues on the faults. At the hearing, our geologist testified that the large thickness of shale strata above the injection interval, which provides extensive shale to shale contact along the fault plane combined with possible shale smearing along the fault plane provides adequate sealing to prevent any vertical migration of formation and or injected fluids along the fault plane. The presence of shale to shale contact across the confining zone strata plus shale smearing within the fault plane precludes vertical transmission of fluids up the fault planes. You heard also about what was referred to as a regional paper. I think it was a Jones paper. The statements in the Jones paper were taken out of context. First of all, the rules, not the Jones paper, governs this proceeding. Secondly, the Jones paper actually says that should a geological investigation reveal that a fault poses a potential pathway for the contamination of USDW, then a monitoring well could be considered. That's directly from the Jones paper. And that's exactly what this system does. The permit requires the completion report, and the completion report can based on the completion report, that could be considered and would be considered by the ED. Finally, the monitoring systems are governed by 331.64. And again, these are all procedures that are put into place after the fact, not before the fact. If you have to drill the well if you have to do all these things before you get the permit, it becomes very difficult, time consuming and expensive to drill the wells and get that site-specific information. So again, we're putting the post-permitting procedures through the pre-permitting procedures, And the fact is the permit requires all of these things that the protestants are complaining about. It's just a matter of when you do it. Thank you.
Thank you, Mr. Techfield. Well, colleagues, here's my view, and I think it's really a policy call about how exacting the commission wants to be on the front end of this process. And in a nutshell, I think what the applicant has done is adequate. So I would, disagree with the ALJs. I believe that UEC has met its burden in describing the local geology and in assessing the faults, that the draft permit provides for adequate monitoring, and that the location and design of the wells and the pre-injection facilities are adequate. Concerning the geology and the faults, as has been described, we do have a two-step process, and permits are generally issued based on a characterization or estimate of the geology. That's step one. Even additional information that's more localized to the site would still be a characterization or an estimate. And so step two, importantly, is to verify those estimates with testing associated with the well completion. And it's that well completion data that's the basis of the agency's decision to allow injection under the permit, or to disallow it, or allow it only with additional requirements. Characterization is imperfect, and we must verify by well completion data. That's always the case. I think it's also the nature of geoscientific practice. You estimate, you characterize, you predict, and then you verify. In characterizing local geology, applicants are not prohibited from interpreting regional data. And in this case, the regional data is evidence that any faults in the area of review are self-sealing so as to prevent the movement of fluids into potential drinking water sources. In addition, the requirements relating to the migration of hazardous constituents are inapposite, since there's no evidence of the presence of hazardous constituents that could migrate out of the injection zone. The draft permit has adequate monitoring requirements, and because the record evidence demonstrates that the Gleinzer and Hausman wells are likely adequately plugged, adding ambient monitoring at this stage would be premature. So colleagues, I think that the applicant has met its burden to make the required demonstrations. I think the protestants have not adequately rebutted that demonstration. And again, any uncertainty about the protectiveness will be resolved before this permit can authorize actual injection. So I have a document that lays out changes that I would propose to the order, and I'd like to hear your thoughts, but would be happy to circulate that change document for your consideration. Commissioner Janeka, what are your views?
Thank you, Chairman. I'll take a moment to review this change document, but I'll just say my initial thoughts approaching this matter align closely with yours. I'm sensitive to the concerns, the policy concerns raised by OPIC in highlighting the opportunities for public review and comment in this process and engagement. But I do feel that the policy established and supported by the executive director does reflect the appropriate balance of interpretation of geological interpretation of available data before drilling, along with the robust set of information and data that are gathered, not just the aspects that have been highlighted by the comments today, but a wealth of other information and data that I know technical staff or executive director staff rely on in reviewing that completion report in that second part of the process. So I'm in agreement, and I'll take a moment now to review.
Let me gather up Commissioner Gonzalez's thoughts, and then I thought we might take a recess. Commissioner Gonzalez?
I'm in agreement with your viewpoint on this, Chairman, and I look forward to reviewing the document.
Okay, why don't we do this? Why don't we take a recess? I've got 9:54. Why don't we break until 5 after, and then reconvene and discuss the document.
And Commissioner, I have emailed you the change document.
Thank you.
All right, the time is now 9:55 and we are in recess. We're back after a short recess. Time is 10:05 on my clock. Commissioners, if you need more time, I'm happy to give you all the time that you need.
Thank you. I've reviewed it and the proposed changes look acceptable.
Okay, Commissioner Gonzalez?
I agree.
All right, any other comments or discussion? All right, well, let me go ahead and offer a motion then. Colleagues, I move that we adopt the ALJ's proposed order as revised by the change document that I've circulated today, that we issue permit numbers WDW 423 and WDW 424 to Uranium Energy Corporation, and that we adopt the executive director's response to comments. That is my motion. Is there a second?
I second.
Motion has been made and seconded. All those in favor say aye.
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 Aye. The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 2 is the consideration of the petition for inquiry filed by Bill Barron seeking a review of the Lone Star Groundwater Conservation District. The commission is limiting presentations to the parties to this matter, and others who have signed in will be noted for the record. The petitioner, Mr. Barron, should go first, followed by the Lone Star Groundwater Conservation District. Any other parties to the proceeding, but presently we don't have any signed in. The ED and then OPIC. The parties will each have 5 minutes of oral argument time, and the petitioner may save time for rebuttal as he bears the burden on his petition.
Good morning, and thank you for scheduling this meeting. My name is Bill Barron.
Mr. Barron, if I can get you to hold on just for a moment.
Okay.
Sir, make sure that the light on your microphone is on.
It's on.
Okay,
Yeah.
I think we're good. Go ahead, sir.
Okay, thank you. And again, thanks for scheduling the meeting. Again, my name is Bill Barron. I'm a proud citizen of Montgomery County. Our Lone Star Groundwater Conservation District Board of Directors, quote, changed its policy goals to move away from sustainability towards a management policy that allows measured aquifer level declines consistent with the desires of the groundwater producers in the district. This statement could be found in Lone Star's response to my petition. It's Exhibit A3, page 2, fourth paragraph. My petition echoes this admission that Lone Star purposely intends to mine the aquifer, although the above statement adds that this policy also meets with the wishes of local groundwater producers. It's difficult for many of us to see how mining our aquifers year after year will preserve, protect, recharge our groundwater, or control subsidence as directed by state law. My petition also is especially critical of Lone Star's current policy because Montgomery County already has a surface water processing facility. It was built at no small cost for the precise purpose of avoiding the very groundwater overuse now sanctioned by Lone Star. Our San Jacinto River Authority's lake water treatment and distribution facilities was intended to provide the necessary alternative surface water for decades to come. While Lone Star's aquifer mining policy may enhance the bottom line of our local groundwater producers, it negatively impacts the entire county when water tables and associated artesian pressures keep trending lower. We've already experienced such trends during which we found out how well production rates decreased, how more wells were required, how wells needed costly lowering, rework, and how resulting subsidence imparted costly damage to homes and other infrastructure. Some of Lone Star's fellow participants in GMA 14 have no alternative surface water source, and their only option is to mine the aquifers. But I see no excuse for Lone Star to lower the bar on its own conservation efforts and intentionally forego the numerous benefits offered by aquifer sustainability. A key legal issue arose a few years back that has become a major impediment towards reconsidering sustainability as a goal. It may also be the major reason your ED and OPIC recommended dismissal of my petition. The issue lies with the original Lone Star mandate that permanently reduced our county's 2009 groundwater allocation by 30%. Following an administrative hearing, Judge Bell presiding, and a later lawsuit, Judge McCorkle presiding, both of which were initiated by a number of parties opposing this groundwater reduction, both judges branded Lone Star's mandate as unreasonable and illegal. However, Lone Star's 30% groundwater reduction mandate was certainly not unique. Both Fort Bend and Harris-Galveston County subsidence districts have imposed identical 30% groundwater reduction mandates some years prior. Since no legal impropriety has been indicated for those two districts' actions, it's odd that these conspicuous and relevant precedents were apparently ignored in the later cases filed against Lone Star. Judge McCorkle's partial summary judgment in late 2018 actually invited an interlocutory appeal to help settle matters by an appellate court, and Lone Star did immediately file such an appeal. However, Lone Star's newly elected board took office soon thereafter and immediately withdrew the appeal. While stating their motive was to end costly litigation, leaving the ruling intact posed a convenient legal disincentive for those who wanted to repeal Lone Star's aquifer mining policy. With both rulings still intact, Judge Bell and Judge McCorkle have inadvertently legislated from the bench. Unfortunately, this kind of legislation can easily instigate ill-founded challenges to other districts' existing or planned groundwater restrictions. A legal dismissal of both rulings would eliminate the obvious cross-purpose with a real legislated intent to judiciously reduce groundwater usage. Since Lone Star is clearly disinclined to challenge these rulings or revoke their aquifer mining policy, I am respectfully appealing to the TCEQ to do so. Thank you for your attention and consideration.
Thank you, Mr. Barron. Colleagues, any questions? Seeing none at this point. Thank you, sir.
We have Stacy Reese for the district.
Good morning.
Good morning, Chairman and General Counsel and Commissioners. Thank you for allowing me to speak. I'm Stacy Reese, the General Counsel for Lone Star Groundwater Conservation District. As you know, GCDs are the preferred method of groundwater management pursuant to Chapter 36 of the Texas Water Code. They are tasked and statutorily mandated to have local control over policy decisions. Effectively, the petitioner is disagreeing with the policy decisions made by the Board of Directors as mandated by the statute. And effectively, also, the petitioner disagrees with legal rulings by an administrative law judge and a court of law. It is illegal for Lone Star to go back and enforce the invalidated DFC and the invalidated reduction rule utilized to achieve the DFC. The current DFC, which is outside of TCEQ's jurisdiction, was approved by all the other GCDs in the GMA unanimously. It was approved by the Texas Water Development Board, and Lone Star has offered evidence that it is on track to achieve that DFC. Disagreement with the policy decisions and the law is not something that's within TCQ's jurisdiction. Additionally, the district has rules in place to protect the aquifer. The district has spacing rules, which minimize interference between wells, help control subsidence. The district also requires hydrogeological reports for certain applications, which analyzes impacts to existing wells that are nearby. We agree with the ED and OPEC's recommendation that there's no evidence that the district is not protecting the aquifer, and we respectfully request dismissal. I'm available if you have any questions.
Thank you, Ms. Reese. Colleagues, any questions? Seeing none, thank you.
Thank you.
So we have the ED.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. I'm Kayla Murray, an attorney in the Environmental Law Division. Here with me today is Abi Barahay of the Water Availability Division, and we are representing the Executive Director. We have reviewed the petition for inquiry and the response filed by Lone Star Groundwater Conservation District. The petitioner, Bill Barron, alleges that the rules adopted by Lone Star do not adequately protect the groundwater in the management area, pursuant to Texas Water Code Section 36.3011B8 and 30 Texas Administrative Code Section 293.23B8. Texas Water Code Section 36.1132 allows a groundwater conservation district to issue permits that result in the total volume of exempt and permitted groundwater production achieving a desired future condition, or a DFC. The petitioner claims that the groundwater production rates in Lone Star's DFCs exceed aquifer recharge rates. The petitioner stated that the district's past use of groundwater has been excessive, and this has resulted in serious declines of water wells production in Montgomery County. He also expressed concerns about potential future effects of the district's DFCs. In Lone Star's response, it stated that the petition lacks supporting documentation. Additionally, Lone Star asserted several reasons that the issues raised by the petitioner are beyond the scope of the TCQ's authority, included but not limited to the following. Only GCDs within a groundwater management area can determine DFCs, and that the TCQ does not have authority to challenge Lone Star's enabling legislation, nor does it have authority over Lone Star's elections. Lastly, Lone Star asserted that it has rules to protect the groundwater in Management Area 14. As stated in the ED's reply brief, the ED has determined the petitioner did not present evidence that showed the groundwater in GMA 14 is not being adequately protected by Lone Star's rules. While the petitioner claims that more groundwater is allowed to be pumped than was previously allowed due to the current DFCs, this does not demonstrate that the groundwater is not being protected. Furthermore, the approval and adoption process of the DFCs is not within the TCQ's authority. Should the commission decide to grant the petition and appoint a review panel, the ED has provided the names of the individuals who responded to the Water Availability Division's requests for volunteers. In conclusion, Lone Star has stated that it is operating within its approved DFCs and that its rules are in compliance with those DFCs. The petition did not provide any evidence otherwise. Therefore, the ED respectfully recommends that the commissioners dismiss the petition. Thank you, and we are available for questions.
Thank you, Ms. Murray. I have none. Any questions, colleagues? Seeing none.
OPIC.
Morning, Mr. Wayne.
Hey, good morning, Chairman, Commissioners, General Counsel, and the Executive Directors, attorneys, and staff. For the record, I'm Sheldon Wayne with the Office of Public Interest Counsel. After review of the petition and Lone Star's response to it, OPIC finds that the petitioner has not put forth sufficient evidence to necessitate further commission inquiry into the district's operations. Therefore, we respectfully recommend that the commission deny this petition. Both Section 36.3011B of the Texas Water Code and Section 293.23 of the Texas Administrative Code provide that an affected person may file a petition with the commission to inquire into the activities of a groundwater conservation district on the basis of 9 listed conditions. Here, the petitioner, Mr. Barron, as owner of land in the management area, is an affected person. Mr. Barron contends that the groundwater in the management area is not adequately protected by the rules adopted by the district. Specifically, he alleges that groundwater production pursuant to the district's desired future conditions greatly exceeds aquifer recharge rates, and if allowed to continue will cause aquifer pressure to decline, compaction of aquifer soils, and subsidence of the aquifers themselves. Mr. Barron advocates for the district to readopt its previous 64,000 acre-feet per year cap on groundwater withdrawal in Montgomery County. However, Lone Star Groundwater Conservation District submitted evidence showing that the 64,000 acre-feet cap was invalidated by a court of law and cannot be implemented. Similarly, the DFCs that were derived from this cap were found to be no longer reasonable by a SOA ALJ, a State Office of Administrative Hearings administrative law judge. And this finding was accepted by the district in an agreed proposal for decision. Given these events, their readoption would not be proper. Additionally, it bears mentioning that the DFCs themselves are not unilaterally established by Lone Star, but instead are established through a collaborative process involving all districts in Groundwater Management Area 14. This process includes joint planning sessions, opportunity for review and comment by the public, approval by a district's representatives and the Texas Water Development Board, and then finally adoption by the districts themselves. Consistent with this, the district's 2022 DFCs have been adopted by GMA 14 and approved by the Texas Water Development Board. As such, and pursuant to Chapter 36 of the Texas Water Code, Lone Star has a statutory obligation to comply with the 2022 DFCs. It appears to OPIC that the district is operating in compliance with Chapter 36 of the Texas Water Code and its own internal rules, which appear adequate to achieve its adopted DFCs. Many of petitioners' contentions take issue with the district's management strategy. However, the district, as governed by its board of directors, is allowed discretion in its policy decisions, and petitioners' disagreement with the district's approach to permitting groundwater does not form a valid basis for the commission to inquire further into the district's actions. In our view, petitioners not demonstrated that the groundwater in GMA 14 is not adequately protected by the rules adopted by the Lone Star Groundwater Conservation District. Accordingly, OPIC recommends denial of the petition. Finally, though we cannot support his petition, we recognize Mr. Barron's good faith efforts to protect and preserve the important resource of groundwater in the state, and we appreciate his participation in this process. Thank you, and I'm available for any questions.
Thank you, Mr. Wayne. I have none. Any questions, colleagues? Okay. Mr. Barron, you do have about 24 seconds left for rebuttal if there's any comments you'd like to add.
Maybe I will. Don't mind.
Sure.
I have no problem with the way Lone Star has handled their business. Their goals are wrong.
Yeah.
That's all.
Yeah.
They have fine people. And I'd hate to see them go just because of that. But if they don't change their goals, our aquifers will suffer. Plain as that. Thank you.
Thank you, sir. Well, colleagues, I think Mr. Barron did an expert job of laying out the history. He communicated his concerns very clearly, made a very compelling case. It doesn't change my analysis, however, and that is that the goal, as Mr. Barron just put it, is outside of our jurisdiction. The petition raises just one issue within our jurisdiction, and that is whether the GMA is adequately protected by district rules. But the petition really doesn't focus on the district's rule, and instead focuses on the desired future conditions, these goals, which again is outside our purview and would be outside the purview of any review panel that we would assemble. So colleagues, pending your thoughts, I would thank the volunteers who were willing to serve on a review panel, but that's not going to be necessary, as I would recommend dismissing the petition. Commissioner Janeka.
I have nothing more to add other than I'm grateful for Mr. Barron's time in addressing this issue. I can't help but notice note the extraordinary attention and effort that is apparent in analyzing and raising a call for an important policy concern. But I think all Texans are grappling with how to appropriately best manage our resources. But I agree with you, Chairman, in terms of moving forward today.
Thank you, Commissioner. Commissioner Gonzalez.
I agree. I can tell that Mr. Barron's just put an inordinate amount of time and effort into making these concerns known, and in some ways wish we did have some jurisdiction to take a look, but I don't think that we do, and I agree with you, Chairman.
All right, I think we're ready for a motion.
I would move that we dismiss the petition for inquiry against Lone Star Groundwater Conservation District.
Second.
The motion has been made and seconded. All those in favor say aye.
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 Aye. The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 3 is the consideration of the petition filed by Circle S Midlothian LLC and HAB 3336 LLC for the creation of Circle S East Municipal Utility District of Ellis County. The parties have been notified that the commissioners will not take oral argument, but may ask questions, and those who have signed in will be noted for the record.
Colleagues, Ellis County's hearing request, I think, clearly demonstrates that it is an affected person. I would grant its request. Commissioner Janeka,
I agree.
Commissioner Gonzalez,
I agree.
I think we're ready for a motion.
I move that we grant the hearing request of Ellis County and refer the matter to SOA for a contested case hearing on the petition.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
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 The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 4 is the consideration of the application by Quadvest LP for new TIPD's permit number WQ00162470001. The parties have been notified that the commissioners will not take oral argument, but may ask questions, and those who have signed in will be noted for the record.
Colleagues, as you know, we have a two-part analysis for considering hearing requests. First, we consider whether the requesters have met the procedural and substantive requirements to be entitled to a contested case. And assuming at least one requester meets the requirements, we then consider which issues are appropriate to refer for hearing. Requesters who are affected in a manner different from the general public and who make timely comments articulating personal concerns that are relevant and material to the application and who express those concerns in a timely hearing request are entitled to a hearing. There are 5 hearing requests on this application, and colleagues, I'll begin with Ms. Sellers. Consistent with the recommendations from the executive director and OPIC, I would grant her request. She raises personal concerns that are relevant material to the application, including impacts to her livestock. I will note that the application seeks a moderate discharge rate of 250,000 gallons per day, and that Ms. Sellers' property is nearly 1.5 miles from the proposed facility. However, her property is much closer to the discharge route. I would deny the remaining requests. The requests by Mr. Martinez and Mr. Burton fail to identify a relevant personal concern, and the Crestus property is simply too far from the facility and discharge point for them to be affected in a manner different from the general public. As for the issues, I would refer to whether the draft permit is protective of animal life and whether the draft permit adequately identifies and characterizes the discharge route. Commissioner Janeka.
I identified the same single affected party and 2 issues.
Commissioner Gonzalez.
I'm in agreement.
I think we're ready for a motion, and I think the only other loose ends is I would probably include an ADR referral on this and allow the full 180 days for the hearing.
I will make the motion. I move that we grant the hearing request of Lisa Sellers, deny all remaining hearing requests, and refer the application to SOA for a contested case hearing on the following issues with a concurrent referral to the ADR program. Issue A, whether the draft permit is protective of animal life, including livestock and existing uses in accordance with the Texas Surface Water Quality Standards in 30 Texas Administrative Code Chapter 307. And issue B, whether the draft permit adequately identifies and properly characterizes the functioning of the discharge route. I finally move to set a hearing duration of 180 days from the date of the preliminary hearing until the proposal for decision is issued.
Second.
The motion has been made and seconded. All those in favor say aye.
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 Aye. Motion carries. Ms. Smith, when you're ready, please call the next item.
Item 5 is the consideration of the application by Leprino Foods Company for new Tipties permit number WQ 000541700. The parties have been notified that the commissioners will not take our oral argument but may ask questions, and those who have signed in will be noted for the record.
So colleagues, again, we have a two-part analysis. Part 1 is about which requesters are entitled to a hearing, and Part 2 is about which issues are referred. Again, requesters who are affected in a manner different from the general public and who make timely comments articulating personal concerns that are relevant and material to the application and who express those concerns in a timely hearing request are entitled to a hearing. Associations can have standing if, among other factors, they identify a member who would have standing in their own right. We have 2 requests on this application, and I want to begin with the Stop Association, which identifies Sonia Fair as a member who would have standing in her own right. I think Ms. Fair has adequately articulated personal concerns about potential impairment of her use and enjoyment of the property. That is a relevant material issue to this application. Her property is about a quarter mile from the proposed outfall and about 300 feet from the receiving lake. And although she does not have an immediate riparian interest, I think she is affected in a manner different from the general public, particularly considering the nature and rate of the proposed discharge. So I would grant Stop's request. I would deny Ms. Anderson's request, however, because she does not explain how she would be affected in a manner not common to members of the general public. So grant 1, deny 1. How did you come out on the parties?
I'm in agreement.
Commissioner Gonzalez.
Also in agreement.
All right, turning to the issues, I would refer the following: whether public notice requirements were met, whether the draft permit is protective of water quality, including with respect to animals and to the existing uses of the receiving waters. I would refer whether the draft permit has adequate monitoring and reporting requirements, whether the application is complete and accurate, and finally, whether the applicant's compliance history warrants denying or altering the terms of the draft permit. Commissioner Janeka, how'd you land on the issues?
I'm in agreement on those issues.
Commissioner Gonzalez?
I agree with the same issues.
All right. There was also, I noted a request for rehearing. I didn't see that it presented any new facts for us to consider, so I would deny that. And again, I think I would include an ADR referral and allow the full 180 days on this item.
I'm with you as well.
I think we're ready for a motion.
I move that we grant the hearing request of Stop the Oppression of Our People, deny all remaining hearing requests and requests for reconsideration, refer the application to SOA for a contested case hearing on the following issues. A, whether applicant substantially complied with applicable public notice requirements. B, whether the draft permit is protective of water quality, including the protection of existing uses of the receiving waters, livestock, and wildlife, in accordance with applicable regulations, including the Texas Surface Water Quality Standards. C, whether the application is complete and accurate. D, whether the applicant's compliance history raises any issues regarding the applicant's ability to comply with the material terms of the permit that warrant denying or altering the terms of the draft permit. And E, whether the draft permit contains adequate monitoring and reporting requirements to demonstrate compliance with its material terms. I'd refer the matter to the Commission's Alternative Dispute Resolution Program to run concurrently with SOA's scheduling process and set a maximum hearing duration of 180 days from the date of the preliminary hearing until the proposal for decision is issued.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
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 Aye. Motion carries. Ms. Smith, when you're ready, please call the next item.
Item 6 is the consideration and hearing on an application from Kaufman County Freshwater Supply District number 3 for additional drainage powers. The district has requested the approval of additional drainage powers and should present the item. followed by any interested persons. However, currently we have no one signed in. The ED, and then OPIC. OGC recommends a standard 5 minutes for oral presentations, and the district may reserve time for rebuttal as it bears the burden of proof on its application. And so with that, we'll begin with the district. Do we have a representative from the district here?
Is it Mr. Martin?
McPhail.
Okay. Well, good morning, sir.
Thank you, Commission. I'll be very brief this morning. We reviewed the recommendation by the Executive Director. We're here to answer any questions as far as the application goes, but we agree with their findings and we'll reserve the rest of our time if you have any questions.
Great. Thank you, sir. I have none. Colleagues, any questions? All right. Ms. Smith, has anybody signed in to speak on this item?
No one has signed in.
All right. So I think we'll turn to the Executive Director.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is Kayla Murray. I'm an attorney with the TCQ Environmental Law Division representing the Executive Director. With me is Justin Tack from the District Section. The Commission received an application from Kaufman County Freshwater Supply District Number 3 requesting the approval of additional powers to provide drainage services as provided in 30 Texas Administrative Code Section 293.15. Based on a review of the application and supporting materials, the district's request to include drainage facilities is feasible and practicable, will benefit the land, and will further public welfare. Therefore, the ED requests that the Commission issue an order granting the district's request for additional powers to provide drainage services. Thank you, and we are available for questions.
Thank you, Ms. Murray. Colleagues, any questions? All right, let's hear from OPIC.
Hi, good morning again, Chairman, Commissioners, General Counsel, and the Executive Director's attorney and staff. For the record, I'm Sheldon Wayne with the Office of Public Interest Counsel. After review of the application and all related agenda backup material, OPIC recommends granting the application and issuing the order granting the district additional powers to provide drainage services within the district as recommended by the Executive Director.
Thank you, Mr. Wayne. I'm not sure I heard anything to rebut. No rebuttal? All right. Thank you, sir. Colleagues, it appears to me that the district has met all the requirements to be granted the additional powers. The proposed order looks good to me, except for one minor correction to a citation, which I'm happy to read into a motion. So pending your thoughts, let me know if you're ready for a motion. Commissioner Janeka.
I'm comfortable with that.
Commissioner Gonzalez.
Also comfortable.
All right. Colleagues, I move that we grant the request from Kaufman County Freshwater Supply District Number 3 for approval of additional drainage powers, that we modify the order to include 30 Texas Administrative Code Section 293.15H1 as the correct notice citation, and that we issue the Executive Director's proposed order.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
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 Aye. The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 7 is the consideration for approval of the TCEQ Chief Auditor's Office Annual Risk Assessment and Fiscal Year 2025 Audit Plan. And the Chief Auditor is here to present the item.
Good morning, Mr. Hardison.
Good morning, Chairman Neerman, Commissioner Janeka, Commissioner Gonzalez, General Counsel, Public Interest Counsel. For the record, my name is Mike Hardison, and I'm the Chief Auditor of the TCEQ. I'm joined today by Ian Bowles, a work lead in my office and project manager for this engagement. We're here today to present and ask approval of the annual risk assessment and TCEQ fiscal year 2025 audit plan. Chapter 2102 of the Government Code requires that the chief auditor prepare a risk-based audit plan and that plan be approved by the commission annually. In order to identify risks facing the agency, my staff and I conducted interviews with individuals charged with governance and other selected TCEQ management and staff. We also surveyed TCEQ division managers and selected staff reviewed external reports of agency processes, performed financial analyses related to funding and expenditures, evaluated turnover and staffing issues, and then used those and other attributes to risk rank concerns identified by my office. The plan before you outlines our planned efforts to address any of those risks identified by the office during this entire process. And at this time, I'd request your approval of the plan. And I welcome any questions you may have.
Thank you, Mr. Hardison. Colleagues, any questions or comments at this point?
I have only one question in my mind. I'm not sure how best to articulate it in a really actionable way, and it's a half facetious question. It's an excuse as much to brag as anything else. Has Chief Auditor's Office considered how they may be overperforming relative to other state agencies of comparable resource in terms of managing our expectations with the state budget writers and leaders?
I appreciate the question. My staff, I feel that my staff does a very good deal of work. As it compares to other agencies, it's hard for me to answer that question because they have other issues and other policies and procedures and whatnot. I believe that my staff is adequately covering the risks identified to us, and we're also allowing ourselves some time for special requests by the commission or the executive director's office to address anything that comes up throughout the year.
Thank you for that response. And I'll just add that I've heard from a number of different sources outside of our agency and inside about how not just satisfactory, but above expectations our auditor's office and functions in our agency really run and operate. And I really commend you on that. And have no questions on this particular report before us today.
Thank you, Commissioner. Commissioner Gonzalez?
It's just a comment. It's just, I'm always really impressed with Mike and the auditor's office and the work they do. And thank you.
All right. Well,
Thank you very much.
Thank you, Mr. Hardison. Thank you, Commissioner Gonzalez. I feel compelled to comment now too. I agree with everything, all the nice words about Mr. Hardison and his team. They do outstanding work. One of the reasons they're able to do outstanding work is the culture within the agency, including the program areas who are forthright with our auditors, who are ready to share all the laundry, clean and dirty, so that we can continue to stay focused on being a well-functioning agency. So certainly hats off to the audit group, hats off to the program areas for not being shy about letting it all hang out and finding out where we have problems and addressing it. All right. Ms. Smith, has anybody signed in to speak on this item?
No one has signed in.
Mr. Arthur.
Good morning, Chairman and Commissioners. For the record, I'm Garrett Arthur, TCEQ Public Interest Counsel. OPIC supports approval of the annual risk assessment and FY25 audit plan as recommended by the Chief Auditor.
Thank you. Colleagues, I do as well. I'm ready to move forward.
I move that we approve the Chief Auditor's Office Fiscal Year 2025 Annual Risk Assessment and Audit Plan as recommended by the Chief Auditor.
I second the motion.
Motion has been made and seconded. All those in favor say aye.
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 Motion carries. Ms. Smith, when you're ready, please call the next item.
And I'll give everybody an opportunity to come up here for item 8 and get situated before I'll call it. Item number 8 is the consideration for approval of the agency's fiscal year 2025 operating budget and fiscal years 2026 and 2027 legislative appropriation request. The executive director and her staff are here to present this item.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, I'm Kelly Keel, the Executive Director at the Texas Commission on Environmental Quality. And thank you for the opportunity to discuss our agency's needs. With me this morning is Janae Burse. She heads up our Budget and Planning Division. And Janae is going to begin by presenting the FY 2025 recommended operating budget. And then I'll provide the recommended legislative appropriations request for fiscal years 26 and 27. All of this information has been compiled in accordance with the General Appropriations Act and guidance provided by the Office of the Governor and the Legislative Budget Board. So with that, I will turn it over to Janae.
I don't know if your light on.
Oh, there you go. Thank you. My name's Janae Burse, and I'm the Deputy Director of the Budget and Planning Division. And I'll start off by walking through the packet on the operating budget. On page 1, it details the total budget for fiscal year 2025, which includes appropriated funds in the TERP Trust Fund. It totals $556 million compared to the FY24 budget of $546 million. This is a decrease of $10 million or 2%. The decrease is mostly attributed to capital funding in the first year of the biennium. The increase in FTEs is attributed to the additional 2 FTEs funded in the contingency rider for House Bill 4256 relating to a grant program for leaking water wells from the last session. On page 2, and y'all please stop me at any time if you have a question. On page 2 provides an illustration of the method of finance for fiscal year 2025, which reflects the appropriated fee funds at 54% and the TERP fee funds at 30% of the total budget, with a total fee funds of 84%. On page 3, this page provides an allocation of FTEs by office. The increase in FTEs is mainly attributed to the move of the monitoring division from the Office of from the Office of Compliance Enforcement to the Office of Air. On page 4, this provides a comparison of the budget by office. The largest change is again the reflection of the movement of the monitoring division to the Office of Air, and also an increase in the TERP funds available. On page 5, this page shows a comparison of the budget by category. Other operating is decreasing by 30 million or 37%, which is mostly in professional temporary services or other operating. This is contributed to the capital items that are typically funded in the first year of the biennium. On page 6, it provides a list of programs supporting remediation, reimbursement, and grant contracts. On page 7 and 8, it provides an overview of the capital budget. And the last page of the operating budget provides a summary of the estimated budget for the TERP program. And the table is updated to and is based on revenue estimates. This concludes the overview of the recommended FY 2025 operating budget. The Executive Director will discuss the proposed legislative appropriations requests. And I can also stop for any questions on the operating
Colleagues,
budget.
any questions from Ms. Burse?
Thank you. None.
I do have one question. Federal funds, the
Yes.
portion of federal funds that contribute to our operating budget, how would you characterize the level of that funding over time? I have a notion of it, but I don't want to give you a leading question, so I'll just leave it open-ended at this point.
Well, it really depends on the type of federal award. We see downward trends of some of the categorical grants, but in this budget, you will see an increase of federal awards, and that is due to the Inflation Reduction Act's Department of Energy Texas Voluntary Marginal Convention Wells Plugging Program, which we were awarded $64.7 million in FY 2025. So if you were just to look at the data in this chart, it would show an increase in federal awards, but that is due to that new grant,
Okay,
which is a special grant and doesn't.
for a particular activity.
For a very particular activity, a voluntary activity, yes. That answers your
Thank you.
question.
That answers my question, and it comports with my understanding of where we are in federal funding. Yeah, thank you. All right, Ms. Keel, LAR.
Thanks, Janae. Commissioners, if you would please turn to the packet entitled Summary of the Recommended 2026-27 Legislative Appropriations Request in your packet. You'll see on pages 1 and 2, it provides an overview of the FY 26 and 27 baseline request of $840 million by method of finance and strategy. This is an increase of $45 million compared to FY 24 and 25. Page 3 details the agency's FY 26 and 27 base capital budget request of $28 million. This is a decrease of $13 million compared to FY 24 and 25. And then looking at pages 4 through 6, this is where we get into our exceptional items request. So the agency is recommending submitting 6 items totaling $115 million and 153 FTEs for the biennium. As an overview, the justification for these requests is to meet the growing and existing demands for agency services, right? So the economy in Texas is prospering, the population is increasing, and there's a number of new federal regulations that we're trying to meet. So we are eager to meet the demands of our stakeholders and the public, but we're currently operating at a little bit of a staff deficit. This has the potential to impact our timeframes for achieving our goals and objectives, like issuing permits, engaging with the public, and implementing information security protocols. So furthermore, as y'all know, our regulatory challenges are complex. And so we're also dealing with emerging technologies, and we need to develop and retain a skilled workforce to meet these challenges and provide predictability and continuity, again, for stakeholders and the public. So these requests are key to TCEQ's ongoing organizational resiliency, as well as retaining delegation of federal programs. So I'm going to go through each priority 1 through 6. So starting with number 1, which is described on page 5 of your packet, this is for hiring additional FTEs to support enhanced permitting, compliance, and public engagement for the agency. Over the last several years, the agency has experienced a rising number in the number of regulated entities. There's also been an increase in public interest and engagement and an expansion of our programs. Additionally, to support counties' drinking water systems and wastewater treatment systems during weather events like wildfires, flooding, and other severe storms, this adds to our workload for our investigators and our program staff specifically. In context, in 2011, the agency took an FTE cut of 8%. That was about 235 FTEs. Since that time, which it's been 13 years, our staffing has remained flat. The population of Texas has increased by about 5 million people, and the GDP of the state has increased by about 33%. So although we strive to serve our residents and in a timely, proactive, and effective manner, with customer service being our top priority, we're concerned that some of these functions may suffer due to constraints for how we're currently operating. So as an example, we're seeing an increase in permit applications. On the water quality front, those permit applications have increased by 60% from FY22 to FY24. Looking at the underground injection control program, applications have grown by 80% there from FY21 to 23. The agency is also hosting more public meetings. We're responding to more complex comments. We're receiving more requests for contested case hearings, and we're providing additional translation services, again, to meet the demands of the public while increasing our transparency as an organization. In FY23, we held more public meetings than we have in any other year in the last 7 years, as an example. In addition to the current workload, we've talked a lot about EPA's revised standards for particulate matter and what that's going to mean for us for new non-attainment areas, as well as that we're working under duplicative ozone standards and other things like the new requirements for methane. So as an example, the federal changes are going to require new state implementation plans for Texas. We're going to have to do additional data analysis, control strategy analysis, and revisions to our permits. So for methane alone, we're looking at 9,600 staff hours to put together those state plans. Also for methane, 2 million staff hours to issue those permits. So pretty staggering numbers for us to consider.
2 million.
Yes, sir.
Thank you.
Drinking water programs are also experiencing changes due to federal regulation. So this is resulting in the need for more complex reviews and requiring expertise from the agency to help regulated entities with compliance and to provide assistance to public water systems. And so as y'all know, we've made every effort to streamline our processes and create efficiencies to maximize the resources that we do have. However, if we don't have sufficient resources and staff, we may start to see those permitting timeframes lag and the ability for us to timely respond to the needs of the public and regulated entities. Moving to exceptional item number 2, which is on page 6. This is a request for salary increases and retention efforts. So the legislature invested in us last session. We were able to increase salaries. Prior to that, we were seeing vacancy numbers in the range of 300 to up to 450 vacancies within the agency. Those salary increases have helped us fill those positions, but we have seen a lot of turnover, which has changed our portfolio in terms of tenure of our employees. So if you look at our employees, about 30% of the staff has 2 years or less experience. About 50% of the staff has less than 5 years experience. Again, fairly staggering. Only 9.5% of our workforce has between 10 and 14 years of experience. And we have 30% of our staff that's eligible for retirement. So we need to, increase pay so that we can retain these employees. That's going to reflect the expertise that's required for the type of work that the agency performs. We're also losing folks to other state agencies, right? So the goal here is to get our salaries up to midpoint, which is consistent with the market rate determined by the state classifications office in terms of our salary ranges. So only 16% of our employees are paid salaries at the midpoint of their salary group. We're losing STEM professionals, engineers, hydrologists to other governmental organizations that can pay more. And so the goal here is to retain and develop staff so that we can continue to develop subject matter expertise and meet the capacity of the growing demand of agency services. Number 3, also on page 6, is related to our administrative functions. Again, this is the growing demand for agency work and our workload. And so the complexities of our agency programs have really impacted administrative functions that are necessary for the agency. This is budget, finance, IT, HR. As y'all know, our finances are complex, especially when you consider our fee structures as well as our dedicated general revenue funding accounts. Also included in here is paying for the increases in our lease costs for our regional offices. Exceptional item number 4 is related to cybersecurity. This is to help us detect and respond expeditiously to any potential threat that the agency may receive. Consistent with federal and state statutes, as y'all know, we house a whole lot of data on really sensitive information such as hazardous chemicals. We have personal information, social security numbers, driver's license, date of births, and we also have detailed information on drinking water systems. So the goal here is to shore up the agency's capabilities to prevent a cybersecurity attack, which could really take down our agency business for a matter of weeks, and we would not be able to function. So looking at exceptional item number 5, this is related to the Department of Information Resources. We have a strong partnership with our sister state agency. This item request is for the interagency contract that we have with DIR, and it's known as the Data Center Services. And the funding associated with this is the request is developed in partnership with DIR. It's for $24 million, and this supports TCEQ servers, databases, applications, websites, our infrastructure equipment, as well as software licensing. And number 6 on our exceptional item request is for the Restore program. So TCEQ manages Restore the Texas Coast as a governor's appointee. The program was created to implement the Gulf Coast Restoration Trust Fund established by Congress when they passed the Restore Act following the Deepwater Horizon spill. So since 2015, TCEQ has received $177 million to fund and implement programs along the Texas coast that improve resiliency. They conserve open space, protect against flooding, attract tourism, mitigate damage, restore habitat, conduct research, develop technology, and promote economic development. So examples of projects are restoring our beaches, dredging drainage canals, acquiring barrier island habitats, improving and developing parks, constructing a sea turtle rescue facility, and development of 2 centers of excellence dedicated to coastal research. So currently there's more than $190 million in untapped restore funds, and as more money becomes available each year. So the current program doesn't have the capacity to keep pace with the funding to implement these projects in a timely manner. And so a lack of sufficient staff can impact the daily demands of developing, executing, and monitoring these contracts and the projects. So as a result, the grants must wait time until the resources are available, which means the costs can go up in the meantime. So we have to reduce the scope of the projects or find additional funding. So moving from exceptional item requests to riders on page 7, beginning on page 7, the agency is recommending 3 rider revisions and 4 new riders. And so I'll highlight a couple of those for y'all, or a few of those for y'all. Rider 14 is the environmental radiation and perpetual care, which removes the funding for the IEC site in Live Oak County and allows for more flexibility in the case of an emergency for that rider. Rider 19 is related to TERP and the grants and administration there. This allows us to match language that the Legislative Budget Board recommended last session. It provides us flexibility to borrow money from the general revenue dedicated account to run our program more efficiently. We're also recommending 2 new proposed riders let's see, one is related to a dedicated fee collected from on-site sewage facility applications to fund research projects. And then on page 9, there's a rider to provide flexibility to the agency as needed for unexpended balances to complete technology projects, which is consistent with what some other agencies are allowed to do. And then also on page 9, 2 new riders to support staff when we respond to emergency or disaster events. So this would allow us to pay for overtime or standby pay, as well as allow us to fund and pay for food and water for our staff when they are unable to leave their duty station during an emergency or disaster response. So with that, that concludes the presentation, and we respectfully request your approval of the recommended FY 2025 operating budget and FY 26-27 legislative appropriations request. In addition, we respectfully request permission to make non-substantive changes to the final documents submitted in accordance with instructions by our oversight agencies. Thank you, and we're available to answer questions.
Thank you, Ms. Keel. Colleagues, any comments or questions?
Thank you.
I just want to say thank you for all the hard work on this. I know a lot of staff time and effort went into putting this together.
I would echo those sentiments. Quite a bit of effort. Appreciate the briefings on this and the recent update. I do have one question because we have Mr. Reed here to comment, and he shared with me some of his comments this morning in a letter. One of them is where we are in our ongoing project to digitize old records so that they're more accessible to the public. And I'm wondering if you know where we are currently on that project and how it's being funded. I know we spent a lot of money on that over the years, and it's an ongoing effort, but do you know where we are on that?
Yes, I can give you an update on that. During the last session, the legislature provided funding, I believe it's $3.5 million per year for a contract for us to digitize those documents and also redact the confidential information from those documents. That was a 3-year project. So the LBB did put the money in our base budget for fiscal year 26 to continue that project. And then we are working with the LBB on some out year costs, some maintenance costs that continue in FY27 and beyond. And we hope to communicate that in the next coming months, so that perhaps is a consideration for the filed version of the bill. If not, we will revisit that in January.
Great, I appreciate that. It's important not just for the public and having greater access to our documents, it also helps the agency out quite a bit. I think roughly over the last decade, we're talking about increased demand on the agency. Our public information requests have grown from somewhere around 3,000, maybe 3,500, I'm not recalling exactly, but to well over 10,000. Those requests create an enormous burden on the agency. I think just about every TCEQ employee could attest to that. Having documents digitized available to the public so we can avoid public information requests also has a benefit in the effectiveness of our staff and how they use their time. So I appreciate the ongoing effort to do that work.
Chairman, I had one question for Executive Staff, if I could. I thought about the salary, exceptional item number 2, salary increase. I wondered, Ms. Keel, if you could just comment generally about how that number was, how we arrived at this number, and does this represent anything in relation to our request for an increase in salaries last legislative session, in which we received some? Could you remind me how much of that request that we asked for last session did we receive, and how much, then how, just speaking very generally, how did we arrive at the number here? And does this represent at all any of that discussion that we had last session?
Janae's graciously reminding me that we requested 56 million last session and we received 28 million of that amount for increase of salaries. And so the goal is to now get us to the midpoint, because that got us part of the way as our salaries were lagging behind. And so the 19 million has the goal of getting all of our employees to the midpoint.
You may not have recalled last session, but did Ms. Pierce, perhaps you followed it more closely. Do you recall which of the different voices of support came in for our agency? Do you recall any voice of support before the legislature for the exceptional item request for that staff salary piece? Or do you also share my recollection that some of the comments about our agency and about that legislative appropriation request were silent on endorsing the idea of, yes, we needed a salary increase?
I'd be happy to answer that question. Last session, we had really a positive feedback from everyone we talked to, from legislative offices to the LBB to the public, because of our high vacancy rates. We were at historic vacancy rates and having a hard time meeting performance measures, et cetera. So that was the solution to helping us fill those positions. And it has worked. They have that money has helped us to fill the positions, but now we are trying to look forward and be strategic about how do we hold on to those people. We have over half of our FTEs are on the career ladder, and there's an expectation that they are promoted as they gain more experience. So we need funding to continue those FTEs progression here at the agency. So that's also included in this exceptional item.
Thank you very much.
All right, thank you so much. Appreciate the presentation. Let me just go ahead and call Cyrus Reed up here. We're on to the interested persons part of the program. And I know he's signed in.
We generally allow 3 minutes for each
Yeah.
person on this.
Yeah. We're ready. Good to see you.
Thank you.
Yeah.
Cyrus Reed, Lone Star Chapter of the Sierra Club. I'm here mainly to support the LAR and the exceptional item requests. I do have a couple additions or changes I'd like to see either now or in the future. I realize it's hard to change something today. So I do very much want to support the base budget request and the exceptional items, particularly exceptional item number 1, because of your backlog, because of the ongoing need to put things digitally and respond to the public, but also because of the methane rule, the PM 2.5, and the various non-attainment areas for ozone. You guys are going to have, whatever happens with court case and elections, you're going to have a lot of work to do. And so I think that's important. one of the comments I made in the written testimony, and this is more of a question or something we can explore in the future, is we want to make sure as part of that exceptional item request, number one, there is sufficient air quality monitoring. I did see on page whatever that you are adding air quality monitoring as part of the exceptional item. It's unclear to us whether that will be enough to cover all the needs, particularly for PM 2.5 and what we believe will be the need for further speciation, so that we can actually, check, is it, as I told you, is it sulfates, is it nitrates? What is actually causing those areas to exceed the new standards? So I think that is going to be important. We only have, I think at the moment, 2 monitors that can speciate. And I do believe on methane, there may be a role. I know industry will have to invest a lot in air quality monitoring for methane, but there may be a role for the TCQ to have monitors throughout the state to look especially for those, super emission events that everyone's concerned about on methane. So I think that's something to look at. And then in my written comments, this is sort of an additional need. I continue to believe that the water program is underfunded, and that in terms of doing the catch up on the backlog of TMDL, and I may have an inaccuracy in my written comments. I think I put a total number. That's not truly the backlog. That's all the TMDLs, but I'll change it in the future. But also looking at things like salinity standards and gradients, continuing to look at produced water. I know you have a couple applications you have to look at. I think there's going to be more needs for the agency. So as we go forward to the legislative session, that's something I want to look at. And I'm going to, again, make the same comment I make every 2 years, which is I believe there's a budget rider that should be removed, which is budget rider 26. This is a leftover budget rider from 2011 that then Senator Hagar put in as a backstop measure while he was working on legislation. The legislation passed. That legislation already says you cannot extend Barnett Shell type regulations to other areas of the state unless you do some further monitoring and analysis. But what this rider says is, and you can't spend any money to do that analysis, that you would need to extend those. So I think it's a policy issue that's put in a rider, and I think it's inappropriate to have it here, and it should be removed. And I'm going to continue to say that as long as I work for the Sierra Club. And if it can be removed, or if there's a way to actually fund that study, I think it's actually going to be important in the methane rule to look at our regulations and whether they should be extended to other areas of the state, because they are more protective in the Barnett Shell. So, and I'll die on that sword. And with that, I'm happy to answer any questions.
Thank you, Mr. Reed. Colleagues, any questions or comments for Mr. Reed?
I had one question, Mr. Reed, and it's diving a little bit into history, so I apologize if you aren't prepared to speak on it today, but do you happen to recall what the position of the Sierra Club was last session when our agency had its legislative appropriation request go before the legislature, and in particular on those exceptional item requests? Did y'all take a position on our exceptional item request requesting staff salary increases?
I don't think we took a position on salary increases. I kind of stayed out of that. We did support, I think, the other exceptional item requests. We certainly supported the transparency and the additional staff needed. I think maybe we weren't against salary increases. We just didn't opine on it. I think it's needed, and I'm happy to, as we get into the public, I think there's going to be a legislative budget board public meeting maybe in October, I think it is. I think I would be happy to support that. I think it is needed.
I sincerely appreciate that. I'm encouraged to hear those words. I noted the absence of a comment or a position last session, and I hope that doesn't support the position that you or any of the similar advocates from the environmental advocacy world are supportive of our agency continuing to grapple with retention problems.
We have disagreements with the agencies on policy issues. We do not disagree that you need to have a full staff and they need to be appropriately paid. So
very much appreciate that. Thank you.
Thank you, Mr. Reed.
Thank you.
Ms. Smith, is anybody else signed in to speak?
No one else is signed in.
Mr. Arthur, what do you think?
Thank you, Chairman. OPIC supports approval of the FY25 operating budget and the FY26/27 LAR as proposed by the Executive Director.
Colleagues, I'm in the same place.
I will move that we approve the Commission's fiscal year 2025 operating budget and fiscal years 2026 through 2027 legislative appropriations request as recommended by the Executive Director.
I second.
The motion has been made and seconded. All those in favor say aye.
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 Motion carries. Ms. Smith, when you're ready, please call the next items.
And that will take us to our enforcement docket, which are items 9 through 60. And the Executive Director's staff is here to present these items.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Michael Parrish of the Enforcement Division, and with me today are Melissa Cordell and Amy Sedemeyer, also of the Enforcement Division, and Gitanjali Yadav of the Litigation Division, representing the Executive Director. Pending before you are items 9 through 60. The total assessed administrative penalties are $2,313,037, with $252,928 deferred, $629,943 applied towards supplemental environmental projects, and $1,430,166 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you, Mr. Parrish. I have none. Colleagues, any questions?
Not at this time.
Ms. Smith, is anybody signed in to speak?
We have a number of individuals on signed in who don't wish to address the commission, but are available if you have questions. And we have folks signed in on 9, 13, 16, 19, 20, 23, 25, 38, and 43.
Thank you. Mr. Arthur, what says OPIC?
OPIC has reviewed each of these enforcement items, and we support adoption of all the orders presented by ED staff.
Thank you. Colleagues, I do as well.
I'm in agreement.
I also agree. I move that we adopt items 9 through 60 as recommended today by the Executive Director.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
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 Motion carries. Ms. Smith, please call the next item.
Item 61 is the consideration of the monthly enforcement report, and the Executive Director's staff is here to present this matter.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is Amy Sedemeyer of the Enforcement Division, and with me are Melissa Cordell of the Enforcement Division and Gitanjali Yadav of the Litigation Division. We are here to present the monthly enforcement report for fiscal year 2024 through June. There were 645 effective administrative orders issued, and of those, 111 contained supplemental environmental projects. These orders assessed a total of $10,303,271 with a payable amount of $4,450,546. $4,611,273 are to be paid towards supplemental environmental projects. 12,588 notices of violation have been issued through either our field offices or review of self-reported data in our central office, and 1,619 enforcement action referrals have been received. There are 3,182 pending administrative orders, with 1,531 cases that are on the backlog. 175 cases are pending at the Attorney General's office for representation in district court, and 7 judgments have been issued. 1,163 cases are being tracked for compliance. I would also like to take a brief moment to recognize 2 enforcement staff who will be retiring at the end of this month. Lindley Doyen and Michael De La Cruz have both spent more than 20 years with the agency, most of which has been in the Enforcement Division. Lindley and Michael are some of the best examples of humble public service that the agency has, In fact, so humble, I was unable to convince them to come to agenda this morning. The Enforcement Division is going to miss both of them greatly, and I know you'll join me in wishing them nothing but the best in retirement. We are available to answer any questions you may have.
Thank you, Ms. Sedmeyer, and thank you for the kind words about your retiring staff. I'm just reflecting on what that's doing to our tenure numbers also. But thank you for that. I have no questions. Commissioner Ginecca.
Well said, Chairman. And I appreciate very much hearing on this report and second the chairman's comments. And thank you for recognizing those staff who are sadly departing. I'm sad to hear we will lose the immediate benefits of their experience, but I just want to recognize and acknowledge how crucial to our agency the work is that your division performs. And in terms of facing different and unique organizational challenges, I think every program area in our agency does have a unique story to tell. Yours is your portion of our agency is one that has weathered a much more acute and torrential storm in recent years. So I think both Lindley and Michael's experience has been really, really outsized, and so we will likely feel it. But I'm encouraged to hear that in the context of this report showing real positive ongoing results that are slow in coming, and hopefully we can continue to rely on this new posture that the division has found in trying to tackle the true challenge that they face. So thank you.
Commissioner Gonzalez.
No comments, just thank you.
Ms. Smith, has anybody signed in to speak?
No one has signed in on the report.
Mr. Arthur?
OPIC has no comment except to say that we appreciate the report.
Thank you for the report, Ms. Sedmeyer. Colleagues, no action is necessary, so Ms. Smith, I'll ask you to please call the next item.
Item number 62 is the consideration of the publication of and hearing on the proposed amendments to 30 Texas Administrative Code, Chapter 30, which is occupational licensing and registration. The Executive Director's staff is here to present this item.
Good morning.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Rebecca Morgan with the Occupational Licensing and Registration Division. With me is Aubrey Puelka with the Environmental Law Division. The proposed rulemaking would implement 3 bills from the 88th Legislature 2023 regular session and incorporate staff recommended changes. House Bill 1845 requires TCEQ to establish provisional licenses for Class D wastewater operators and public water system operators for persons without a high school diploma or equivalent. HB 2453 allows licensing agencies to issue a digital license in lieu of a paper license. Senate Bill 422 requires the TCEQ process applications and issue the license for qualified military service members, veterans, or spouses within 30 days of receipt. The proposed rulemaking would also require public water system operators to take resiliency training to better equip licensed operators, public water systems, and affected utilities, and help them prepare for, respond to, and recover from severe weather-related events. The proposed rulemaking would require all applicants for new and renewal licenses to subscribe to the FBI fingerprinting for the criminal history reviews, unless a waiver to submit criminal history information in an alternate method is requested and approved. The proposed rulemaking would also reduce the number of continuing education credits required to renew the leaking petroleum storage tank project manager license from 32 hours to 20 hours. Additionally, the proposed rulemaking would update training terminology to be consistent with current training technology and policies. A hybrid virtual and in-person public hearing will be offered on this proposal in Austin on October 10th, 2024. Staff respectfully recommends approval to propose the publication of and hearing on October 10th for Chapter 30 occupational licenses and registrations. Staff also respectfully requests permission to make non-substantive revisions to comply with Texas Register requirements. Thank you, and we are available for any questions.
Thank you, Ms. Morgan. I have none. Colleagues, any questions? Seeing none. Ms. Smith, is anybody signed in to speak?
No one has signed in.
Mr. Arthur or Ms. Jameson, good morning again.
Good morning again, Chairman, Commissioners, General Counsel, and Executive Directors, Attorneys, and staff. For the record, I'm Jennifer Jameson on behalf of OPIC. OPIC has reviewed this rulemaking and respectfully recommends publication of the proposed amendments to relevant sections of 30 TAC Chapter 30 regarding occupational licensing regulations. OPIC notes the potential benefit to the public of this rulemaking in that the new rules will allow more people to benefit from licensed water operators that are better equipped and qualified to respond to emergency events, and the enhanced public safety that will derive from increased criminal history checks. OPIC also notes the benefits in this rulemaking geared toward issuance of licenses to qualified military service members, veterans, or spouses, and language that extends opportunities for persons to obtain provisional water D or provisional wastewater D licenses to those who have met all training requirements but have not obtained their high school diploma. Lastly, OPIC would like to ensure that any final language is consistent with 30 TAC Section 53.021B, which prescribes automatic revocation of an occupational license following felony imprisonment conviction or parole probation violation. OPIC is concerned that this language may be overly broad and unintentionally encompass misdemeanor convictions or revocations. We will consider this issue during the comment period and prior to adoption. OPIC will continue to follow publication proceedings of this rulemaking as they progress, and we will remain a resource to the public throughout.
Thank you, Ms. Jameson. Colleagues, I'm happy where we are with the proposed rule and I'm ready to hear what the public thinks about it.
I'm in agreement.
Also in agreement.
I move that we approve the publication of and hearing on the proposed amendments and additions to 30 Texas Administrative Code Chapter 30, Occupational Licenses and Registrations, as recommended by the Executive Director.
A second.
The motion has been made and seconded. All those in favor say aye.
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 Motion carries. Ms. Smith, when you're ready, please call the next items.
That will take us to items 63 through 66, which are the quadrennial rule reviews for chapters 279, 311, 312, and 321, Texas Administrative Code, Title 30, and the Executive Director's staff is here to present these matters.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I'm Gwen Rico with the General Law Division. Pending before you are items 63 through 66, the adopted rule reviews of 30 Texas Administrative Code, Chapter 279, Water Quality Certification, Chapter 311, Watershed Protection Rules, Chapter 312, Sludge Use, Disposal, and Transportation, and Chapter 321, Control of Certain Activities by Rural. As required by Texas Government Code Section 2001.039, Executive Director staff conducted a rule review of these chapters to determine if the need for the rules within these chapters continue to exist. The proposed notices for these reviews were published in the May 31st, 2024 issue of the Texas Register with 30-day comment periods. No comments were received for these rules reviews. Based on the review of these chapters, the Executive Director has determined that the reasons for the rules in chapters 279, 311, 312, and 321 continue to exist, and changes to the rules identified as part of this process will be addressed in a separate rulemaking action in accordance with the Texas Administrative Procedure Act. In conclusion, we respectfully recommend approval of the adoption of the rule reviews of chapters 279, 311, 312, and 321. Additionally, staff requests authorization to make non-substantive revisions necessary to comply with Texas Register requirements. Thank you. The project managers and staff attorneys assigned to these chapters are here to answer any questions.
Thank you, Ms. Rico. I have none. Any questions, colleagues? Ms. Smith, is anybody?
No questions.
Sorry, Ms. Gonzalez?
I just said no questions.
Okay, I'm sorry. Is anybody signed in to speak?
No one
Okay,
signed in.
Mr. Arthur.
For each of these 4 chapters, OPIC considered 3 things. 1, whether public comments were received. 2, whether any rules were found obsolete. And 3, whether the rules are still needed. None of the chapters received public comments and no rules were found obsolete. The Chapter 279 rules are still needed to govern the issuance of state water quality certifications under the Federal Clean Water Act and to implement the certification and notice provisions of Section 401 of the Act. The Chapter 311 rules are still needed to protect certain water quality areas by either prohibiting discharges or defining effluent quality for discharges in specific watersheds. The Chapter 312 rules are still needed to regulate the processing, use, and disposal of sewage sludge, domestic septage, water treatment sludge, and the transportation of these and other liquid wastes. Further, these rules implement Texas Health and Safety Code Chapter 361 provisions and protect water quality under Texas Water Code Chapter 26. The Chapter 321 rules are necessary because permits by rule are still needed for numerous discharges that are more efficiently authorized by rule than individual permit. In conclusion, OPIC agrees that the reasons for initially adopting the Chapter 279, 311, 312, and 321 rules continue to exist, and we support readoption of these chapters.
Thank you, Mr. Arthur. Colleagues, for the reasons laid out by the ED and OPIC, I'm ready to readopt these chapters.
Likewise.
I move that we adopt the rule reviews and readopt the rules in 30 Texas Administrative Code Chapters 279, 311, 312, and 321 without amendment as recommended by the Executive Director.
I second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith? Now it carries unanimously. Ms. Smith, please call the next items.
The next items are for closed session, and the commission will meet in closed session in room 246, partially virtually, of the Texas Workforce Commission at, shall we say, 11:33.
Sure.
As permitted by the Open Meetings Act, including Texas Government Code Sections 551, 071, and 074 to take up and consider matters pursuant to item number 67 through 70 as posted and noticed.
The time is 11:30. We are in recess.
The commission met in room 246 of the Texas Workforce Commission from 11:33 a.m. until 11:40 a.m. on item number 69, as noticed and posted pursuant to Texas Government Code Section 551.074. No action was taken, and this agenda stands adjourned. The time is 11:47.